This case, item 4 for Pandisur, item 1st April 3 of 2023.
आप ही लेके आए हैं आर्गुमेंट्स? आप लेके आए हैं अपना आर्गुमेंट्स?
Not yet come forward. I will argue that one time.
क्योंकि कंफ्यूज आपको बोले थे लेके आने के लिए, क्यों नहीं लेके आए? आना चाहिए था। आर्गुमेंट कंक्लूड होने के बाद फिर क्या होता है कि लोग नया नया कहानी शुरू कर देते हैं, इसलिए हम नहीं पसंद करते हैं। एनीवेज आप ठीक है, कोई नहीं दिए हैं तो ऐसा कोई ज़रूरी भी नहीं। आपने लाए
I have prepared, लेकिन और थोड़ा
कंफ्यूज होगा, कोई बात नहीं।
ठीक है।
कम से कम एक पता तो चले ना हम लोग को कहाँ पॉइंट ऑफ डिटर्मिनेशन आप बना के लाए हैं कि हमको बनाना है, हम बना लेंगे।
I'll do one by one if I can suggest you.
Yes.
Because the main allegation was on the fraud. If the fraud is proved, then obviously, therefore, that is the one of the main point for determination whether the plaintiff respondent, whether the partnership deed was a creation of fraud.
Partnership deed was not a creation of
Partnership deed.
Partnership deed by itself was not a creation of fraud. It
They
was a
say,
registered
yes.
document.
No, they say that registration is absolutely not mandatory under the Partnership Act. So, execution of the document they do not dispute. They say that because it was fraudulent representation was there with regard to the partnership business, and therefore they had entered into partnership and they signed and they gave money to the plaintiff, to the original Samir Kumar Yadav. This is their case.
Partnership deed के कौन-कौन है signatory?
Yes. Your Lordship is
We have seen the partnership deed. Let's have a look at the
deed itself.
एक बात बताइए, जो
Yes.
फर्स्ट appellate court का judgment है, उसमें case of respective parties has been rightly
No, this is the first appeal.
नहीं, ये जो फर्स्ट अपील में जो जजमेंट जो है, जो इम्प्यून जजमेंट है, इसमें केस ऑफ रेस्पेक्टिव पार्टीज हैज बीन राइटली नरेटेड।
Yes.
आप काइंडली उसको
हाँ.
यू जस्ट गिव इट अ जिससे कम से कम थोड़ा सा, उस दिन तो हम लोग थोड़ा सुने थे, लेकिन फिर भी एक बार इसको थोड़ा सा इसको
I'll
बताइए।
start.
और एक चीज उसके पहले बता दीजिए कि पार्टनरशिप डीड में कौन-कौन सिग्नेटरी है?
Yes. The first two plaintiffs.
First two plaintiffs, Ramashankar Rai
Yes.
and
Dinanath Roy and the husband of defendant number 1 and father of defendant number 2. That means Samir Kumar Yadav.
Defendant number?
1 is the wife of Samir Kumar Yadav, who was the third
And
partner.
father of?
And the defendant number 2 is the daughter. So there were altogether 3 partners. Undisputedly, their names were mentioned. That these were the 3 partners.
Yes.
And then
Yes.
they make out a case that Samir Kumar Yadav, I'll read it out that.
हाँ. पढ़िए तो जरा एकदम तेजी से पढ़ेंगे ना, बाय लाज हम लोग का पढ़ाई हुआ है।
That the plaintiffs have brought the suit for recovery of 29 lakh only as principal interest and at the rate of 18% per annum till realization so and so. Case of the plaintiff is as follows. Samir Kumar Yadav, since deceased, husband of defendant number 1 and father of defendant number 2, executed a deed of partnership with plaintiffs on 29/11/2012, and the said deed of partnership was registered before the sub-registrar Charles Bocaro by registered deed of so and so 29/11/2012. So here they say that it was registered before the district sub-registrar, but no statement that it was registered before the registrar of firms. So subsequently it has come that it was not registered before the registrar.
Yes, fair.
So this is one of the main point for determination which your lordship would have to frame, whether the suit would be was barred in terms of section 69 of the Partnership Act, because this was
You
primary
see, the
objection.
partnership firm is neither the plaintiff nor the defendant.
No.
Still, the suit would be barred.
Yes. It would be barred in terms of section 69(1).
In a case where the partnership is not registered, what is the status of the parties?
That consequence itself, it has been mentioned, your lordship may
That is-
only allow you to
Partnership
place that because
Because that is at the
yeah,
court.
absolutely, absolutely. This is my main objection. Now, 59 says,
दिखाइए जरा। और दूसरा चीज हम ये आर्बिट्रेशन पर भी आप लोग से सुनना चाहेंगे। Do you have to say anything on arbitration clause, or you have nothing to say?
no, I thought over it. Your lordship, section 8, with regard to section 8 of Arbitration and Conciliation Act. Now, if I do not file any objection, or if I take a defense and I leave it there, I did not request the court to refer the matter to the parties for arbitration, then subsequently if the matter proceeds and ultimately the matter is decided on merit, then it cannot be said that it was absolutely illegal or non-est in the eye.
You want to plead waiver?
Because section 4 of Arbitration and Conciliation Act also says so. So therefore I am not making my submissions with regard to section 8 of the Arbitration and Conciliation. What that would do, your lordship, I thought over it and therefore I am making this submission. Otherwise I would not have made this submission. Now,
Just a moment. There is a judgment of Delhi High Court which says that mere raising an objection under in the written statement is as good as
yes,
asking the court
yes,
to refer the matter for further.
absolutely. But if I can,
Then I will record that you are foregoing this.
no, not because of that. Now here, if I have gone to this must have been a case where the matter was tested whether the reference ought to have been made on. This was not a case where the after this order, then the finally the matter proceeded and final order came. This was challenge to the proceeding under section 8 itself. So here is a
आपने
case.
देखा है दिल्ली हाई कोर्ट का ये?
हम देखे थे इसलिए. Then I'll answer to this subsequently.
You see, it is one thing to say that this issue you give up. It is another thing to say you don't want to give up this issue. Then we'll have to decide. You can't have it both ways, right? Because that is one of the issues. And I am supposed to decide all the issues which have been raised before the court. Unless both of you give up that you don't want to contest on this issue. You say you don't want to contest, I'll record it. Otherwise, it has to be decided. Isn't it? That is the law. All the
Yes,
issues
yes,
are to be
absolutely.
decided. Think over it. Right? Think over it. If you don't want to go by that, that is a separate thing. But once the issue is there, we will decide all the issues.
Absolutely. But Your Lordship, I said that I may be allowed to answer it at a subsequent stage.
It's
That-
okay. No problem.
That is
We were on
only-
the plate. So
Yes.
this was what was going on in my mind.
Your
So
Lordship, many a times I'm not making submission with regard to this particular matter. Now, why I made this submission was that under section 9 of Code of Civil Procedure, there is very clearly it says that the civil court would have the power to decide all the suits unless barred. So there has to be a very specific bar in any other law which says that no, the suit would not be maintainable. So in entire Arbitration and Conciliation Act, there is not a single section which says that the civil suit would be barred if there is an arbitration act. It does not say so. So therefore this submission was there. But this is only academic purpose. I may be allowed to address it at subsequent point, and I'll research, and till now I could not get it. Now
Yes,
with regard to the effect of registration, Your Lordship, there are two kinds of registration. First is registration obviously under the Registration Act. Second is registration under the Partnership Act. So now with regard to the first registration under the Registration Act, it is the registration of the deed itself, not of the firm.
that will not replace the registration required under
Yes. And the requirement of Partnership Act is that the firm has to be registered before the registrar, and that is there in section 59 of Partnership Act, where the registrar is satisfied that the provisions of section 58 have been duly complied with, he shall record an entry of the statement in a register called Register of Firms and shall file the statement. So therefore there has to be entry in the Register of Firms with regard to the partnership firm. Then Your Lordship may see the consequence of non-registration, which is there in section 69. And our case is squarely covered by 69(1) itself. Effect of non-registration. No suit to enforce a right arising from a contract or conferred by this Act shall be instituted in any court or on behalf of any person suing as a partner in the firm. Here I'll
आगे
put emphasis.
आगे
Yes.
पढ़िए.
Partner suing as a partner in a firm against the firm or any person alleged to be or have been partner in the firm unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. So there are several requirements that he must have been, the partnership deed itself must have been registered, the partner must have been shown as a partner in the register of firms maintained by the registrar of firms, and then if he would have filed a suit, then suit would be maintainable against the firm or any person who is a partner of the firm or other person. So here specific bar that no suit itself is maintainable if unless he, that means the person who is suing has been shown as a partner in the register of firms. So absolute bar, and then subclause 2 is with regard to the partnership firm suing any third party. This is not our case, therefore we are squarely covered by section 69 bar.
My question is something else.
Yes,
There is a partnership firm, unregistered.
yes,
If somebody wants to sue for the accounts of that
yes,
transaction, if not partnership,
yes, absolutely.
then what is the method and how?
Method here itself it has been mentioned that is taken out. That is exception is it is there in subclause 3.
Yes.
The provisions of subsection 1 and 2 shall apply also to a claim or set off or other proceeding to enforce a right arising from a contract, but shall not affect. That means your lordship, non-registration would not affect the enforcement of any right to sue for dissolution of a firm or for accounts of a dissolved firm or for any right or power to realize the property of a dissolved firm. So this is an exception.
It is not a status of at the stage of dissolution, because there were altogether 3 partners.
Yes.
Only one of them has expired, right? So it is not a case of dissolution of firm, because the firm was still existing.
But if they could have, they would have sued for dissolution of the firm and for accounts of the firm. That ultimately the deceased was also a partner, and now it was required that the partnership firm had certain properties and the accounts were required to be settled, and therefore they could have sued for dissolution and for obviously accounting.
In such
of the
circumstances, the partnership firm would have been made a party,
yes,
right?
Yes.
For accounts, etc.
yes,
Their suit, as they have framed, considering the party position, does not reflect that they are claiming any relief against the partnership. They are claiming relief amongst themselves
among themselves.
by saying that such and such partner, his status was of a partner, had taken money and had not invested in the firm. And therefore, the money which they had given to one of the partners did not form a pool of the partnership money, and therefore he indicated that on the last date, and therefore there was neither any need for dissolution of partnership firm nor any need to make partnership firm as party, and this was essentially not for account of the partnership property. Their entire case is that they had given money to the 2 persons, to Mr.
Samir Kumar.
Mr. Samir Kumar Yadav, who did not use it for the firm, and he defrauded them by taking the money, and they are seeking refund of that money which was given to Samir Kumar.
But all this was in as a partner of the firm. The basis is the partnership firm. Therefore, they say that your lordship may now test the. Allow me to read the plaintiff,
Yes.
because that is the ultimate story which has to be seen.
आप बैठ जाइए, आपका टर्न अभी आने में टाइम। आराम से, हम बहुत आराम से सुनते हैं, एकदम इत्मीनान से। क्वेश्चंस इसलिए पूछते हैं कि वे अपने माइंड को क्लियर करना जरूरी है, ठीक है? आप सिर्फ 2 सवाल पूछ लिए, इसका मतलब ये नहीं कि आपके अगेंस्ट में सोच रहे हैं।
या मेरे भी अगेंस्ट में पूछा
ऐसा कुछ, it's not like that. Now we have to clear our mind to give a clear judgment. चलिए, पढ़िए।
It is stated that prior to execution of the, I'm reading page 2.
हाँ, हाँ।
Prior to execution of partnership deed, Samir Kumar Yadav induced the plaintiff to enter into a partnership for land development business for one of the project at Moja Bhawanipur at the rate Solangidi. Samir Kumar Yadav told the plaintiff that he had already invested rupees 25 lakh in this project, and for further investment Samir Kumar Yadav told the plaintiff that they would be added as partners in this project, and by doing this project the plaintiff would get immense profit. Believing upon the words of Samir Kumar Yadav, the plaintiff paid rupees 29 lakh to Samir Kumar Yadav on different dates for land development business. So now, Your Lordship may also allow me to point out certain things here.
Yes.
The starting lines, Your Lordship may see, it is stated that prior to execution of partnership deed, Samir Kumar Yadav induced the plaintiff to enter into a partnership for land development business. So here, according to them, this was a wrong inducement that was given, and this was actually a false pretense. Therefore, they are making this statement that actually there was no such business which was running. Samir Kumar Yadav was not doing any such business. This is ultimately what is the outcome of the entire thing. It is stated that Samir Kumar Yadav showed about 40 acres of vast tract of land pertaining to Khata number 96, plot number so and so, and other plots of the same Khata of Mauja Bhavanipur, Solangiri. Samir Kumar Yadav projected very rosy picture regarding land development business, and upon his insistence, the plaintiff paid 29 lakh to Samir Kumar Yadav. Initially, the plaintiff paid only 5 lakh to Samir Kumar Yadav, and thereafter the plaintiffs had financial crunch. Therefore, they approached plaintiff pro forma defendant Sri Ramdas Singh to provide monetary help to them for the development of the business, and the pro forma defendant had agreed to pay amount to the plaintiff so that the plaintiff may give the amount to the Samir Kumar Yadav for smooth running of the business. The pro forma defendant, Sri R.T. Singh, had given check of rupees so and so 3 lakh only in the name of Samir Kumar Yadav to the plaintiff so that the amount may be withdrawn by Samir Kumar Yadav for the development of the partnership business, and the said amount of rupees 3 lakh only had been shown in the accounts of the plaintiffs in the partnership business. So here from this statement again I will show. Here it actually shows that all the three partners, they were acting in furtherance of the partnership deed together, jointly, and it was not Samir Kumar Yadav who was alone doing anything. They themselves say that they approached R.T. Singh paid to them. It is further stated that pro forma defendant had also given check of rupees so and so 5 lakh, and all details I am skipping here. And in the name of Samir Kumar Yadav to the plaintiff, and in this manner total amount of rupees 13 lakh was taken by the plaintiff from pro forma defendant, and they had given the said amount to Samir Kumar Yadav for development of the business. So here again, they themselves admit very clearly in their pleading that they had taken this 13 lakh and then they paid it to Samir Kumar.
The entire payment is post entering into partnership.
Yes, absolutely.
After.
After. All after partnership. This partnership is dated December 2012.
No, November 2012.
November 2012.
29 November 2012.
And Your Lordship would find that all the checks are,
Post. Even the cash is post.
yes,
(29/11/2012) is the partnership date, and all the payments in the name of Samir Kumar Yadav is post this date.
post this date, yes.
And this particular deed,
No, Your Lordship, I got 2 checks, which chart has been mentioned in page 3. Your Lordship would find the date is not wrong. The dates are 15/3/2012 and 16/3/2012.
date is 10/12/12, 4/10/13, 25/1/13, 1/2/13. The date is mentioned in the chart.
Yes, but last two in the
16/3.
chart.
One is 16/3.
15/3/2012 and 16/3/2012, and Your Lordship, the partnership deed was executed on 29/11.
Yes.
Therefore, this actually I had skipped my. So therefore, the 5 lakh rupees is in the month of March 2012, prior to entering into the partnership. But
And
no
this
such pleading is there.
deed is referring to 7,50,000 by second partner and 7,50,000 by third partner.
Yes.
Okay.
Yes. It is stated that plaintiff made payment to Samir Kumar Yadav in the following manner by way of check and cash, details of which have been given below, and then details of which is total amount is rupees 29 lakh. Samir Kumar Yadav, my learned friend pointed out that it has been wrongly typed as 2012, it is actually 2013. In the judgment, it has been wrongly typed as 2012.
Date बताएंगे
Whereas-
सबका?
The plaint says
Cash
16/3/2013. It is actually 15/3/2013. That means the check number 341403 is dated 15/3/2013. Wrongly typed as 2012.
2012.
And the next one is check number 341402. This is dated 16/3/2013.
So all these transactions are post partnership.
Yes. I'm thankful to him for correcting. Your Lordship may allow me to read further. Samir Kumar Yadav has also executed 3 money receipts for the amount which he had taken from the plaintiffs on different dates. After making such a huge investment of rupees 29 lakh, the plaintiff started to inquire from Samir Kumar Yadav regarding the status of financial condition of the business, and he, on some pretext or the other, did not give the actual status of the financial position of the partnership business. And later on, upon inquiry made by the plaintiff, they found that no land for land development business was ever purchased by Samir Kumar Yadav, and in order to deceive the amount of the plaintiff, Samir Kumar Yadav executed a deed of partnership business, though actually no partnership business was started, as nothing was invested by Samir Kumar Yadav in the business, and he had taken 29 lakh from the plaintiff by playing fraud.
Please pause for a moment.
Yes.
These money receipts were issued by Samir Kumar Yadav.
Yes.
And they were all in his individual capacity. The partnership deed further did not contemplate any investment on your part. And all the checks were issued in the name of Samir Kumar. Samir Kumar Yadav has 2 personalities, one in the capacity of partner of the partnership firm and other in his individual capacity. Now you say that this money was taken by him for investment in the partnership firm, but he did not invest. So does this money form a part of partnership pool?
Our claim is because he had already died, the widow and daughter were absolutely unaware, therefore they had denied this
We will
entire
come to that
transaction.
You see, we will come to that later. I was thinking about this case for a couple of days. And in case of death of a person, the recovery is only to the extent of his assets, right? Merely because somebody is a legal heir of a person, the entire property of the legal heir will not be subject matter of attachment. You said on the last date that the house has been attached. In whose name the house is standing?
House, it was probably in the name of Samir Kumar Yadav.
So basically it is his property which
Yes.
has devolved.
Not attached, it was taken over without any valuation, without auction
That
sale.
is a separate thing.
Yes.
That is a separate thing.
Yes.
But on the face of these averments and on the face of the partnership deed, the partnership deed is not contemplating that any further investment will be made. But the transactions reveal that checks and cash was given to Samir Kumar Yadav
Yes.
there is no transaction between any bank account created in the name of partnership deed. So it will be a matter of concern as to whether the transaction which was being entered by Sameer Kumar Yadav and between the and the plaintiffs, was it for the purposes of running the firm, or it was for the purposes of or in his individual capacity. This would come up. Proceed.
Yes. Now, partnership deed itself mentioned that he, Sameer Kumar Yadav, had invested 25 lakh and therefore it contemplated further investment by the other two defendants. And other investment has not been mentioned, that what the parties, what they would invest further. Now, let us assume that it does not contemplate anything, that any further investment would be made or not made. Then the partnership deed itself is only of 2-3 clauses where they say that we are entering into partnership. So if they actually invest, then would it be again the partnership, the terms and conditions of the partnership, whether they could have subsequent to the entering into partnership, whether they could have subsequently they could have agreed to invest amount or that was required that no, we have to first amend the partnership deed itself and then only
you see,
can
it is
make
one
an
thing to
investment.
say that after the creation of partnership deed, there was a bank account in the name of partnership deed and partners were contributing to it. It is not a case of that nature. Here, the other partners are issuing checks in the name of another partner. For the purposes of using it in the...
This is a fact which requires clarification. Here, the person who is issuing a check, he is not a partner of the firm. The person who is issuing a check, he is defendant number 3, who is absolutely an outsider.
And he says that he has been instructed by the other partners to...
Yes, what the plaintiffs make out a case, that the two plaintiffs say that defendant Sameer Kumar Yadav entered into a partnership business with us and on his request, we approached defendant number 3, we took money. This is the statement, exact statement. We took money, not Sameer Kumar Yadav. We took money and then we gave it to Sameer Kumar Yadav. And the money receipt also which has been produced has been given by not by Sameer Kumar Yadav. It has been given by the plaintiff themselves. Absolutely strange. Now, if the plaintiff themselves take certain amount from the defendant number 3, they give him a money receipt in which Sameer Kumar Yadav is not acknowledging payment, receipt of payment. He is only signing as a witness. Then how liability on him can be fastened on the basis of a money receipt? And their whole statement is that no, they also say that we took money and then we gave it to Sameer Kumar Yadav. So they took money, then they would pay. Why would Sameer Kumar Yadav pay? And Your Lordship, the clause of the partnership firm was that the first partner has already invested, second and third partner were investing 7,50,000. It does not say that they would not in future invest further.
It can't be.
So,
For firm, they will go on investing.
Yes.
There is no problem.
So here they say, then they make out. So therefore, Your Lordship would find from the pleading that the whole case which the plaintiffs are making is that there was actually no partnership firm, and Sameer Kumar Yadav, under false pretense, he actually deceived the plaintiffs from that amount, and then he used it for his own personal purpose. When he was confronted, then also they did not file any suit, any notice whatsoever. They do not do so. And
We come to internal page 2. Initially, the plaintiffs paid rupees 5 lakhs. Let us see the nature of transaction amongst them.
Yes.
Initially, the plaintiffs paid rupees 5 lakhs.
Yes. This I had,
Samir
I had admitted on the first date itself that this is the only amount they say that they have paid to me.
Yes.
Rest all I'll read.
And thereafter?
And thereafter, the plaintiffs had, not defendant
That's
number
right,
3,
that's
Samir
right.
Kumar, had financial crunch. Therefore, they approached, again the plaintiff approached,
Yes.
pro forma defendant Sri Ramdas Singh to provide money, help, monetary help to them
That's
for development of the business, and the pro forma defendant had agreed to pay the amount to the plaintiff,
That's
so that the plaintiff may give this amount to Samir Kumar Yadav for smooth running of the business.
That's right.
So absolutely clear that it is they who are taking the money. They themselves very clearly said that they are the persons who are taking
And
the
the
money.
pro forma defendant has not filed any case
Strange.
for recovery
This
of
is what,
money
this is what I say.
from Samir Kumar Yadav.
Samir, he does not file. How the payment made by your pro forma defendant, how can he can ride on a boat on the suit filed by the plaintiff number 1 and 2?
And it is the plaintiffs who are borrowing the money from the pro forma
Yes.
defendant. And therefore, there is a contract between the plaintiff and the pro forma defendant.
Yes, yes.
And the
absolutely.
other defendants, according to you, have got nothing to do.
Nothing to do. Particularly when the defendant number 3 himself does not come forward to make a claim. His claim was never adjudicated. How can in a suit filed by plaintiff number 1 and 2 against the Samir Kumar Yadav, who was a third partner, how can a claim of the pro forma defendant can be adjudicated in the instance?
That's right. Okay.
And whatever amount was being taken, it was very clear that it was being taken by the plaintiffs, not by Samir Kumar. And then I'll read further, Your Lordship. Your Lordship, I'll request only one thing. Your Lordship may now see the statement where they, despite having knowledge about the fraud, let us say that Samir Kumar Yadav had committed fraud, according to their own statement, what they did, they were required to plead specifically and then to prove also. So I'll just read out the statement made further, or before reading this, can I refer to Order 6 Rule 4, which says that whenever there is a pleading with regard to fraud, coercion, undue influence, specific particulars have to be given.
That's right, we'll take
Yes,
care of
yes.
that. So there is no specific pleading regarding
Absolutely lacking, absolutely. General allegation, that is all. This I'll show subsequently from evidences also.
Yes.
Both the plaintiffs were examined as PWs and I'll show them. I was in page number 4 here. Second paragraph.
Yes, yes.
It is stated that when the plaintiffs got information that Samir Kumar Yadav had no land at Mauja Bhawanipur in Khata number 96, then the plaintiffs started making demand of refund of their amount, which was taken by Samir Kumar Yadav. Samir Kumar Yadav, in order to make part payment of the amount taken, issued 3 post-dated checks of IndusInd Bank. Details of the checks are as follows: 10 lakh rupees in there. After some days, after issuance of post-dated check, Samir Kumar Yadav told the plaintiff that he was suffering from some disease, and he advised the plaintiff not to deposit the aforesaid check for encashment. Believing upon the words of Samir Kumar Yadav, the plaintiff number 1 did not deposit the aforesaid check in his account, and in the meantime, Samir Kumar Yadav sold, left for heavenly abode on 14/5/2014. After the death of Samir Kumar Yadav, the defendant number 1 and 2 have all inherited the properties of Samir Kumar Yadav, and they are enjoying the same. It is further submitted that Samir Kumar Yadav has constructed a multi-storied building as Chira Chas, and the defendants have inherited the same and are in possession of the same and are enjoying the property also. It is stated that the plaintiff number 1 got a legal notice issued on 14/10/2014 to defendant number 1 for making payment of rupees 29 lakh within 15 days from the receipt of legal notice making payment of, and instead of making payment of 29 lakh, the defendant number 1 got the legal notice replied through her lawyer Pankaj Prasad on the ground. So here I'll pause, Your Lordship. Your Lordship may see the date of legal notice, that is 14/10/2014, and prior to this they themselves say that they had detected the fraud committed during the lifetime. No legal notice, no complaint, nothing of any sort was done by them.
And what were the dates of these checks?
This,
These are all exhibited
yes,
documents?
yes. They have been. This is 10/4/2012 to 2014.
All of them? 41.
Then 21/4/2014, and then 5/5/2014. Just before his death.
He committed
Then-
suicide or?
Cancer. The case of the defendant number 1 and 2, as stated in their written statement to the plaintiff, are as follows: that the contents of para 1 of the plaintiff are admitted. However, the answering defendants submit that they are neither partners of the said firm nor privy to any act, deed, or things done by the partners among themselves or with any other party. The contents of the para 2 of the plaintiff are false, that late Samir Kumar Yadav induced the plaintiff to enter into a partnership, therefore denied. The answering defendant further state that the partnership deed dated 29/11/2012 bears testimony of the terms and conditions of the partnership and many other details as agreed amongst the partners. Therefore, anything contrary to what has been drawn up in the said deed of partnership is emphatically denied. It is denied that there was any inducement by late Samir Kumar Yadav to the plaintiff. The contents of para 3 of the plaintiff are false, hence denied by the answering defendants. The defendants were not privy to what transpired amongst the three partners in connection with or in reaction to the partnership business. It would be relation to the partnership business. As such, the answering defendants specifically denied the statement made in para 3 of the plaintiff as an attempt to assassinate the character of a dead person. It is stated that so far as payment of rupees 29 lakh is concerned, it is to be noted that the partnership deed was executed on 29/11/2012, wherein contribution of late Samir Kumar Yadav has been acknowledged as 50% share in the profit as well as loss of the partnership business. On the other hand, the plaintiff number 1 and 2 had contributed 7,50,000 each to the partnership capital fund, and each was entitled to a share of 25% in profit and loss of the partnership business. Clearly, the late Samir Kumar Yadav's contribution to the partnership, to the said partnership, was not less than 50% or rupees 15 lakh. It is further stated that the contents of the table drawn up in para 5 of the plaintiff show that all the payments as allegedly made by the plaintiff are posterior to the constitution of the partnership firm. So, at the same can at best be described as investment in the business of the firm, although the answering defendants deny the same emphatically because of the lack of their knowledge and information. The contents of para 4 of the plaintiff are false and hence denied. The answering defendants are or were not privy to arrangement transaction that took place between the plaintiff and the pro forma defendant. It is the pertinent to, at this juncture, to refer to the legal notice dated 14/10/2014 served upon defendant number 1 on behalf of plaintiff number 1, wherein there is no reference to pro forma defendant regarding the payment made by him, and the plaintiffs have claimed entire amount as their own. It is further stated that when the plaintiff's words are taken on their face value, they are not entitled to claim any payment that has been made by pro forma dependent, because pro forma dependent was neither a partner of the firm nor in any way concerned with the said partnership business. So far as payment made in cash are concerned, the answering dependents deny them. It appears that the plaintiffs have doctored money receipts in order to further the ill will. Furthermore, even if the allegations are assumed correct for the sake of argument, which does not include slightest of admission by these defendants, it shows the remittance of payment to the firm in which the answering defendant had no role to play. It is important to refer to para 1 of the legal notice dated 14/10/2014, where there was no hint or suggestion that such payment was made by stranger, namely Ramdas Singh. So if Ramdas Singh had made any contribution to partnership firm as put forth by plaintiff, the firm alone shall be responsible, otherwise also the plaintiffs have no legal right or locus standi to claim this amount. Nevertheless, there appears a deep-rooted conspiracy among the plaintiff and pro forma dependent, who are all hell-bent to encroach upon the only dwelling house of the dependent, as reflected in para 11 of the plaintiff itself. It is pertinent to mention here that the said notice by Anand Varnam was served on 14/10/2014, and before that the advocate of R.D. Singh conspired with Allahabad Bank to cause a legal notice upon the dependent number 1 to demanding rupees 29 lakh so and so. The said notice was replied to by dependent number 1 through a lawyer, wherein details of CC of so and so was demanded. The bank never replied to the said notice. The dependent number 1 thereafter filed an application under section 17 of the Securitization and Reconstruction of Financial Asset and Enforcement of so and so, and before the DRT Ranchi, praying therein for relief of setting aside quashing of notice dated so and so by the bank upon the dependent number 1. It appears that after receiving the notice from the Honorable DRT, the pro forma dependent Ramdas Singh entered into a conspiracy with the plaintiffs herein to set forth a claim of rupees 29 lakh. It is therefore submitted that the instant suit is just a ploy of the pro forma dependent to wriggle out money from the dependent number 1 and 2 after he failed in his earlier attempt to do so in tandem with Allahabad Bank. It is further submitted that the plaintiff itself suggests that the plaintiff has not paid a single pie other than which has been expressly admitted in the deed of partnership dated so and so. The contents of para 8 of the plaint are false, hence denied. The answering defendant do not know about the assets of or land owned by the partnership firm. As such, the statement made in relation to khata number so and so Bhawanipur is denied. With respect to the statement made in para 9 of the plaint, answering defendant submit that they are not aware about issuance of any such check by late Samir Kumar Yadav. All these document checks etc. related to the partnership business were kept at partnership office at so and so, as provided in clause 1 and 2 of the deed of partnership dated so and so. The plaintiff gathered all the document instrument record that were kept in the partnership office after the death of Samir Kumar Yadav. It is pertinent to note here that after the death of husband of defendant number 1 and father of defendant number 2 on 14/5/2014, plaintiff did not inform the defendant in particular or public in general whether the plaintiffs are surviving partners have reconstituted the partnership firm or not. It is relevant that section 42C of the Partnership Act, a partnership firm dissolves on the death of a partner. In case there are more than 2 partners, the surviving partners are free to reconstitute the firm and continue with the project. It is further stated that and submitted that the property of the firm includes the property right, interest and goodwill over which only the plaintiffs have full control. The answering defendants neither have any knowledge of the same nor they were made party to the said agreement. From a simple reading of partnership deed, it is more clear that late Samir Kumar Yadav had invested a sum of rupees 15 lakh in the partnership venture against total sum of rupees 15 lakh jointly contributed by the 2 plaintiffs. it is illegal to demand that I paused here because I think the earlier amount of 15 lakhs has been wrongly written because he had actually invested 25 lakh but was not. It is illegal to demand the contributed amount back from the legal representatives of the dead partner by surviving partner. The content of paragraph 12 of the plaintiff are matters of record, hence need no comment. However, it is stated that there was no reference to the said Sri Ram Das Singh in the said notice dated notice issued by so and so, lawyer for the plaintiff number 1. Such statement are just an afterthought with respect to the statement made in paragraph 13 and 14 of the plaintiff are concerned. It is submitted that the plaintiffs have no cause of action to institute the suit which primarily seeks relief in the nature of settlement of account. The suit is not maintainable as submitted under the heading preliminary objections in the written statement. The plaintiffs are not entitled to claim any amount, much less the amount of 29 lakh from the defendant. The defendants as legal representatives of Samir Kumar Yadav seek to set forth a counterclaim against so and so, and they claim
There is a transaction between Samir Kumar Yadav and defendant number 3.
Yes.
He mortgaged the property.
Properties, it is not clear. That has not come in.
Became the guarantor.
He had become guarantor. He had become a guarantor of Ramdas Singh.
Ramdas Singh.
Yes.
Samir Kumar.
Yes.
Samir Kumar Yadav had become the guarantor of Ramdas Singh, and then the loan account of Samir Kumar Yadav was Ramdas Singh was the loan account of Samir Kumar Yadav was enhanced.
That clarity is not there in it.
You see, the point is that this defendant number 3 has issued check in the name of Samir Kumar Yadav. Under the provisions of Negotiable Instruments Act, check can be negotiated and it can be, it can go to any third person for an encashment, and then after negotiation, the third party has got the right to take the money. It is like if A has some dues against B and B also has to realize some money, there can be an inter-party transactions through check, and there is a system of negotiation. But here is no negotiation. Here the check is being directly issued by these three by defendant number 3 in the name of Samir Kumar. And there is some transactions between Samir Kumar Yadav and the defendant number 3. Normally, whenever a property is mortgaged, there is some kind of money transaction between the parties. It happens.
Yes, but for that Ramdas Singh would either
Yes.
come
No,
or
I'm not.
Yes, yes.
I'm observing something
Yes,
in your
yes.
favor only. Everything is not against you when
Yes, yes.
we are just looking at the transaction
yes,
as to how the parties have behaved. There is some kind of transaction. Ramdas Singh is not a stranger to Samir Kumar. Yeah. There is some kind of transaction between Ramdas Singh and Samir Kumar Yadav, and Ramdas Singh had credited certain amount to Samir Kumar Yadav for the purposes of enhancement of loan of Samir Kumar Yadav, and this particular who mortgaged the property, Samir Kumar Yadav became the guarantor.
It must have been the account of the
Samir Kumar Yadav.
No.
The Ramdas Singh.
Ramdas. In Ramdas Singh's account, he must have mortgaged, but that we'll verify.
It is there in the written statement.
That clarity is not there. It says that
You just
it
have a
was
look at
mortgaged and
the defendant number 3 told Samir he has not enough money in his bank account. He has one cash credit account. You read page number 10.
page number 10.
10. The defendant number 3 further told. Yes.
Told Samir Kumar Yadav that he had not enough money in his bank account and he had one cash credit account in Allahabad Bank having limit of so and so, and that has been used for business purposes. After hearing this, Samir Kumar Yadav told defendant number 3 that the bank has not given loan to him, therefore the defendant number 3 might enhance his limit of his cash credit account lying with the Allahabad Bank, so and so. So here I am pausing your Lordship. Why, as your Lordship pointed out, how this particular transaction could have been adjudicated by in a suit filed by the plaintiff. The plaintiffs could not have taken advantage of any transaction between R.D. Singh to Samir Kumar Yadav. It might have been anything. What was their internal arrangement between them?
What
So-
I am looking through is, which appears to be unwritten, as to why this defendant number 3 did not come forward to recover his money.
What has happened actually? Now there is an exhibit. Whatever I am saying from recordings. One exhibit is there where it is between the two plaintiff and Ramdas Singh, where they say that before they had actually taken money. I don't want to misquote, therefore your Lordship may allow me to read that. This is exhibit. This was the reason. This is exhibit A. Exhibit A.
Exhibit A.
A.
What is it?
This is transaction between where the two plaintiffs, they are giving money receipt to Ramdas Singh. It is only 1.5 pages.
Yes.
रुपए का प्राप्ति रसीद हम लोग दोनों दीनानाथ राय एवं रमाशंकर राय सो एंड सो ने आज दिनांक 4/2/2012 तारीख को निम्न बयान श्री रामदास सिंह पिता सो एंड सो कोऑपरेटिव बोकारो के पक्ष में लिख के दे रहे हैं ताकि हम दोनों कानूनन इससे पालन करने के लिए बाध्य रहें तथा इसके वास्ते यह प्राप्ति रसीद एक प्रमाण रहे। बयान यह है कि मौजा भवानीपुर उर्फ सोलांगी डी मौजा सो भूखंड का डेवलप कर व्यवसाय करने वास्ते हम दोनों के अलावे श्री समीर कुमार यादव के साथ एक साझानामा दस्तावेज दिनांक 19/12/2012 को चास के बंदर कार्यालय में संपादित हुआ है। यह कि इसी साझानामा में पूंजी लगाने की नियत से आपसे दिनांक 4/1/2013 तारीख को 3 लाख रुपए सो एंड सो 5 लाख रुपए एंड ऑल दीज अमाउंट्स हैव बीन मेंशन निर्गत है प्राप्त कर चुके हैं। यह कि नेक्स्ट पेज, यह कि उपरोक्त रकम को प्राप्त कर हम दोनों ने आपको इस पार्टनरशिप डीड में अपने हिस्से में भागीदार बनाया। इसी उद्देश्य से यह प्राप्ति रसीद आपके पक्ष में हम दोनों ने अपने शरीर एवं मन से स्वस्थ अवस्था में सोच समझकर so what they were doing, they had taken this amount, they made him a partner in the with regard to whatever share they had. So therefore this was the reason they had taken money from defendant number 3 and they invested in the partnership. This was the reason.
But here, while taking money from defendant number 3 and investing in the firm,
Yes.
whatever, Samir Kumar Yadav has no role to play. This is what at
Yes,
best you can say.
absolutely. Whatever document, although I'll also show that one document absolutely forced. Apparently, your Lordship would find it forced. So, whenever they are creating in order to meet out a certain case, whatever they have pleaded, and then in order to fulfill whatever document they are creating, they are trying to show that there was a partnership business and they are making investment. So, how can only one partner be made liable when the document itself shows that they were acting in unison. Everyone was acting in terms of the partnership. Even if their entire case is admitted, then also. So one hand they say that they took money, they invested for development of business and all these statements. And then when it comes to liability, then they say that no, he was the alone, he had deceived us, and then he was the only person who was liable to me. So that again, because that question has come up, your lordship may see apparent forgery also. One money receipt, your lordship may see that money receipt
The
is.
facts are very complicated.
No, why I pointed out, your lordship may see.
I've seen so many money transactions
Yes.
of this of this nature, but this appears to be quite complicated. Anyways,
This is exhibit. This is money receipt dated 25/5/2013, and this was marked as exhibit 2/8 or 2/8 or B. Not clear.
yes, money prapti receipt, exhibit 2/2 with objection.
Yes. The stamp is numbered as 910785 at the top right hand.
Yes.
Yes. Exhibit was 2/2. Yes. Your lordship may see the date of issuance of the this stamp by the stamp vendor. That is in the next page, 23/5/2013.
Yes.
Then your lordship may turn to the first page. On the next date, that means 25/5/2013. This is the date on which the money receipt is being prepared. So this is post. That means in the money receipt is said to have been made in the month of May 2013. And when your lordship may turn to the next page again, when this was issued by the Treasury Office on the right hand side
7/8.
corner, 7/8, it was issued in the month of August 2013. And how can a money receipt which is being issued by the Treasury itself can be issued by the stamp vendor antedated, and then this for the first time comes out from the Treasury on 7/8/2013. And in our law, there is absolutely no punishment for any false evidence. Therefore, suits are prolonged. We file forged documents, and so I'll proceed further here.
Okay, time.
So I'll come to the next point here.
Let us see the issues framed. You can see the issues framed by the court.
Yes, this was.
You want to place something more on facts?
Few law points are there, because there are 2-3 judgments. I will not file too many judgments. I will not rely on too many judgments. The Honorable Court says whenever, and this is based on section 92 of Evidence Act, which says that whenever something is written and reduced into writing, then no oral evidence is permissible. So first, your lordship may allow me to read section 92 of the Evidence Act, and then how the Honorable Supreme Court has interpreted these two clauses, Order 6 Rule 4 of the CPC and section 92 of the Evidence Act. What would be the impact? Because their whole case is dependent on the fact that they are saying that Samir Kumar Yadav had played fraud upon them by misrepresentation, that there was some business in which they were induced to invest certain amount, and then they invested certain. So then The section 92 says exclusion of evidence of oral agreement when the terms of any contract, grant or other disposition of property or any matter required by law to be reduced into the form of a document have been proved according to the last section. No evidence of any oral agreement or statement shall be admitted as between the parties to such instrument or so and so. And then proviso says any fact which may be proved to invalidate any document which would entitle the person to any degree or fraud, intimidation is there. That means fraud was committed and therefore we had entered into an agreement. This is precisely they are making the case. So then what the court says that
No, they are not talking about any document being fraudulently prepared. Their case is that this money was given for the purposes of partnership,
no,
but Samir Kumar Yadav had diverted it.
no. They say their whole starting statement you're watching that before entering into partnership, Samir Kumar Yadav had induced
them to.
So therefore there was inducement prior to entering into a partnership. Therefore this is what they are saying. So how this has to be proved, that is what the Honorable Court says. If once you have reduced some terms into a writing, you have agreed and then you take a plea of fraud, then what is required to be
The
pleaded?
terms of condition does not say that they will be investing any money.
No,
Further.
no. But it does not debar also.
Certainly it does
They
not.
could have done. So, please, Your Lordship, because I'll be after this I'll be summing up with the evidences only, because this cropped up. Therefore, may I first place the judgment or first the
No,
evidences?
I'm still not able to comprehend as to why do you need to refer to section 92 at all.
For the reason that because their whole case is that
they were fraudulently induced.
induced.
Yes.
That means this was prior to entering into agreement.
That's right.
This is the thing which they are trying to. Once it has been reduced into writing, then this plea cannot be taken. That is what I am saying. My submission is, once you have reduced into writing, the terms of the agreement have been reduced into writing, then you cannot take any plea. You have to only admit the partnership, and if you say that there was inducement or fraud committed, then you are required to prove to an extent which has been now been said by the Honorable Court. Because there is a proviso to section
See, at
92
the time
which says,
when they are entering into the agreement, how do they know they have been wrongly induced or fraudulently induced? The question of fraudulent inducement will come only when it comes to their discovery that yes, this money was not invested, or maybe that he had no business.
yes,
But this is something which is coming up later.
yes, that
So how do you expect that this kind of allegation would have any kind of reflection in the partnership deed?
no, it
And
would not.
It would not, and therefore there is no oral evidence to contradict the partnership.
No. So
None of you are contradicting the partnership deed.
we are not. But once my submission is, once you are reducing into writing something,
Yes.
then you cannot lead evidence, or this is leading evidence because they are making a pleading that prior to entering into agreement, we were induced to enter into a
That's right.
partnership.
How do they know? When do they know that they have been fraudulently induced? Subsequently.
So
That is post partnership deed.
absolutely.
Then under such circumstances,
Absolutely.
what is the contradiction in their evidence, which is a contradiction between oral and documentary evidence, to call for any kind of application of section
92, because there is a proviso.
Yes.
Now, section 92 proviso says that if you have been defrauded into entering into agreement, then you can prove fraud. This is what proviso says. Now this is precisely what they are saying, that although there was a written agreement, but that was based upon a fraud that was committed by Samir Kumar Yadav. So that fraud, how that fraud has to be proved, that is what the Honorable Court says, that once you have written something and entered into an agreement, then you cannot just brush aside the agreement and say that a fraud was committed.
All the
This-
payments in this case
Yes.
is coming up post partnership.
Yes.
Right? So at that point of time, there was no occasion, nothing in neither anything is mentioned in the partnership deed that how much money will they provide, nor there was any occasion to say because money was yet to come. Right? When the money came, when they paid the money, they found that some fraud was committed. This particular promise which was there, this money has been fraudulently taken by them by showing that there was some business. Right? So, therefore, under such circumstances, it is not a case where some oral transaction has been written in writing. It is a case where there is some agreement, and later on some payment was made, and then the plaintiffs realized that this payment which they had agreed to pay earlier or whatever, they were fraudulently induced to make this payment, and this is how this allegation of fraud comes. At the time of putting the document in place, there was no element of fraud. There was no payment also. There was nothing.
My submission is, why I am making this submission is that there is a deed of partnership which shows that the partners are acting in furtherance of a partnership deed. So then you cannot lead evidence to contradict the terms of partnership, and then you cannot say that no, everything was fraudulent and there was no partnership at all which was being done. So all this is being done only to escape the consequence of section 69. Because if they do not make this plea, then their suit would be barred in terms of section 69.
By making this plea, they are out of the
Absolutely,
bar.
because they say that it was this, and this is what the trial court has ultimately found. It has said that fraud was committed, and therefore there was no the bar of section 69 would not come into play. This is the finding.
Is that legally correct?
No, because on two aspects. First was that the plaintiff were required to make specific pleading in terms of section 6,
Yes,
order 6 rule 4.
Foundational pleading is not there.
No, not there. No date whatsoever that when they came to know the partnership was entered in in the month of December 2012. Samir Kumar Yadav dies 1.5 years thereafter. During this time, they themselves admit that they had come to know that there was no such partnership business or there was no such land, and they knew that they had been deceived. No date of knowledge has been mentioned, no legal notice, no complaint whatsoever, no suit, nothing of any sort was ever raised by them. And for the first time, it is only after the death of Samir Kumar Yadav, all these things were started. So once they say that they came to know, then that date and other further pleadings were required to have been stated. Now, if your Lordship could see the evidences of both the plaintiffs, only relevant portions are placed, and then your Lordship may, because their evidence, own evidence is in.
How many witnesses are there?
3 witnesses, but only 2 I will be referring, both the plaintiff, that is all. I'll skip the evidence or note because all the same statement of the plaintiff has been stated. Cross-examination, paragraph 15 में kindly we see. This I am referring to PW1. मैंने समीर कुमार यादव द्वारा निर्गत किया हुआ प्राप्ति रसीद दिनांक इतना इतना की मूल प्रति न्यायालय में दाखिल किया है, जिसे मैं प्रवर्तनता हूँ प्रदर्श 2 अंकित किया गया विरोध के साथ. This was marked with objection. Then para 22. मैंने पार्टनरशिप डीड के तहत मुकदमा लाया हूँ. So therefore he himself admits that he had brought the suit as in the capacity of a partner, and if this statement is taken, then his suit is barred in terms of section 69. Then partnership deed सब रजिस्ट्री चार्ज में निबंधित हुआ था. Then para 33. I am skipping other portions. Para 33. पार्टनरशिप डीड के प्रथम पृष्ठ में इस बात का उल्लेख है कि समीर कुमार यादव 25 लाख रुपए का वर्णित प्रोजेक्ट में निवेश कर चुके हैं. पैरा 39. समीर कुमार यादव की मृत्यु घटना में हुई थी. 42.
ये 25 लाख का उनका इन्वेस्टमेंट का जिक्र है.
हाँ, डीड में भी है और यहाँ पर वो एडमिट भी कर रहे हैं कि वैसा लिखा हुआ है. देन 42 में मैंने 29/11/2012 से 14/5/2014 के बीच में समीर कुमार यादव को शपथ पत्र में लिखे गए धोखेबाजी के बारे में कोई लिखित नोटिस नहीं दिया. पुनः कहते हैं कि मैंने लिखित न देकर मौखिक रूप से बहुत बार बोले हैं. दिस स्टेटमेंट इज वेरी इंपॉर्टेंट. He had repeated complaint against Samir Kumar Yadav, but he does not initiate any or issues any legal notice. Then para 43. मैंने स्वर्गीय समीर कुमार यादव एवं उनके जीवन काल में कोई दीवानी एवं फौजदारी मुकदमा नहीं किया. स्वतः कहते हैं कि अपने जीवन काल में समीर कुमार यादव अग्री कर चुके थे. मैंने आपसे पैसा लिया है, जो आपका पैसा थोड़ा थोड़ा करके वापस कर देंगे, इस बात की जानकारी उनकी पत्नी को भी है. देन पैरा 49. मैंने ओम दीनानाथ रामदास को लिख कर दिया था कि आपकी भी हिस्सेदार होंगे, आप भी हिस्सेदार होंगे. पैरा 50. इस संबंध में मैंने पार्टनरशिप डीड में कोई संशोधन नहीं किया और न ही उनके रामदास सिंह पार्टनरशिप डीड के पार्टनर के रूप में नामित किया. देन पैरा 53. वही खाता के संबंध में समीर कुमार यादव को न व्यक्तिगत रूप से और न ही अपने अधिवक्ता के माध्यम से लिखित नोटिस नहीं दिया. स्वतः कहते हैं कि मैंने कई बार मौखिक मांग की है. देन पैरा 57. ऐसी बात नहीं है कि मैं एवं दीनानाथ और रामदास सिंह मिलकर प्रभा एंथनी यादव को संपत्ति और कानून का दुरुपयोग करके हड़पने का प्रयास कर रहे हैं. ऐसी बात नहीं है कि सो एंड सो. एंड देन 59. इस बात की जानकारी मुझे बाद में हुई कि यह डीड ऑफ पार्टनरशिप रजिस्ट्रार ऑफ फर्म के द्वारा निबंधित नहीं है. Then PW2. Evidence only para 3 or para 4 of the evidence or note, the same statement has been made. And then para 8 here. यह कि स्वर्गीय समीर कुमार यादव के रवैये से परेशान होकर वादीगण में जब स्वयं भवानीपुर मौजा जाकर जमीन की स्थिति के बारे में पता किया तो जानकारी मिली कि स्वर्गीय समीर कुमार यादव ने वादीगण के साथ छल किया कर पैसा हड़प लिया है तथा स्वर्गीय समीर कुमार यादव का भवानीपुर मौजा में किसी प्रकार का कोई हित नहीं है और न ही भवानीपुर मौजा में स्वर्गीय समीर कुमार यादव ने कोई कार्य प्रारंभ किया है. उपरोक्त तथ्य की जानकारी मिलने पर वादीगण ने स्वर्गीय समीर कुमार यादव से अपने पैसे की मांग किया और पैसे की मांग के पश्चात स्वर्गीय समीर कुमार यादव ने इंडसइंड बैंक के ये चेक दिया. देन Then your Lordship may skip to the cross-examination. Again, para 19, यह कि समीर कुमार यादव द्वारा हम लोगों को रुपया ठगे जाने का कोई शिकायत थाना अनाधिकारी के पास नहीं किया. 22, प्रोफॉर्मा डिपेंडेंट से हम लोगों की दोस्ती लगभग 25 वर्षों से है. Then 29, दिनांक 29/12, same statement that between this time there no complaint whatsoever was made to any of the authorities, and then deed of partnership was not registered. And then 32, पार्टनर द्वारा समीर कुमार यादव के जीवित रहने पर कोई भी मुकदमा नहीं किया. एंड देन 34 and 34, यह कि यह वाद लाया हुआ पार्टनरशिप डीड में कथित धोखाधड़ी के तहत किया गया है. यह बात पार्टनरशिप डीड में लिखी हुई है कि पार्टनर व्यापार निवेश किया है, और यह भी लिखा है कि लाभ एवं हानि निवेश के अनुपात में सभी पार्टनर लाभ हानि के हिस्सेदार होंगे. This is all. So I just wanted to show from this evidence, Your Lordship, that both the witnesses, they were aware, both the plaintiff, that despite their awareness about the so-called fraud committed by the Samir Kumar Yadav, they themselves say no complaint whatsoever was lodged before anyone. One question is missing, no date whatsoever was there when they discovered about the fraud. And lastly, that as Your Lordship had firstly, on the first date Your Lordship had asked, the land was not such a land which could have been hidden. It was an open statement that where the Samir Kumar Yadav had very clearly mentioned the plot and the area where he was doing development business, and if this was a fraudulent, then they could have very well checked from the reports. Only two judgments I will be referring, Your Lordship. One is, what is the degree of evidence that is, or pleading that is required to be led in matters where the parties rely on statement of fraud. This is a second. Directly para 40 years. With all due respect to the learned judge, we fail to understand the reasoning. Section 92 of the Evidence Act bars the court from looking into oral evidence once the contract is executed in writing, as except as provided in the 6 provisos therefore. Again, it appears that the High Court has not found a strong prima facie case against defendant number 4 merely on the reading of the claim. Pleadings, here statement, pleading make only allegations or averment of fact. Mere pleading do not make a strong case of prima facie fraud. The material and evidences has to show it. No material whatsoever is referred to by the High Court. And then the Honorable Court refers to para 42. In so and so, the Privy Council held that fraud, like any other charge of a criminal offence, whether made in a civil or criminal proceeding, must be established beyond reasonable doubt. A finding of fraud cannot be based on suspicion and conjecture. And then again section 92. So therefore this is what they are doing. Whatever statement they have made, it is only a conjecture and nothing else. Then the another judgment is this was although a suit where the suit was directly filed, which was in contravention of section 34 Surface Act. Then on the ground of fraud, this was the pleading for not referring or going before the
Yet.
para 7 onwards. We have heard in length it is the case of the, on behalf of the plaintiff appellant hearing, that in the plaint there are allegations of fraud with respect to assignment agreement dated so and so, and the case on behalf of the plaintiff appellant hearing, assignment agreement is fraudulent in as much as the full payment as per approved resolution plan under the IBC so and so is fraudulent. Therefore, it is the case on behalf of the plaintiff appellant hearing that the suit in which there are allegations of fraud with respect to the assignment deed shall be maintainable and the bar under section 34 of SARFAESI Act shall not be applicable. However, it is required to be noted that except the fraudulent, there are no specific particulars pleaded with respect to the fraud. It appears that by clever drafting and using the word fraudulent without any specific particulars with respect to the fraud, the plaintiff appellant hearing intends to get out of the bar under section 34 of SARFAESI Act and wants the suit to be maintainable. As per settled proposition of law, mere mentioning of the word and using the word fraudulent is not sufficient to satisfy the test of fraud. As per settled proposition of law, such a pleading using the word fraudulent without any material particulars would not tantamount to pleading of fraud in so and so, and then your Lordship para 9 also.
Merely to make a plaint maintainable, you just cannot say fraud and get away with the jurisdiction objection.
Yes. And here what they say, their whole plea is based on fraud, and therefore they impliedly intend to make out a case that therefore that bar would not run. And therefore para 9 of the same judgment, same thing has been.
Now at least touch upon the findings recorded by the court. Touch upon the findings which has been recorded by the court.
Yes. But ultimately, your Lordship, pleading was also not there. That is what the Honorable Court is saying. That particulars of fraud are not there, are lacking in the pleading also. So, pleading and proof, both material particulars are required to be pleaded.
Then para 5 at page number 12 of the judgment is dealing with the first point, preliminary objection. Let us see what the court has held. This is 69-2 objection.
It is same judgment.
The impugned judgment.
Yes.
We need to see the impugned judgment.
Yes.
The defendant number 3 had a counterclaim.
No. Defendants have not filed any.
The defendant number 3 seeks to set forth a counterclaim against the plaintiffs.
We had said it. Yes, defendant number 3 had said, but no such counterclaim was filed. These are marked also.
Anyway, let us see preliminary objection first.
Yes. The following objections shall go to the root of the matter in dispute and without prejudice to each of the POs so and so, and to be dismissed on each of the ground. Section 69(2) of the Partnership Act 1932 provides as
This
under.
is principle of law. Let proceed further.
Yes. The present partnership deed, after 3-4 lines,
Yes.
the present partnership deed which is relied upon by the plaintiff is admittedly registered with the district sub-registry Bokaro and not with the registrar firm as required under section 58 and 59 of the Indian Partnership Act, and as such no suit can be filed by the firm or any of the partners on behalf of the firm against a third party, that is the defendant. The said partnership agreement contains a clause number 7 which provides for resolution of dispute by the arbitrator. As such, in view of section 5 of Arbitration and Conciliation Act, the present suit is barred. The plaintiff in the plaint have admitted execution of the partnership deed dated 29/11/2012, registered before sub-registry Charles Bokaro, and as such the fact of partnership and relationship of the three partners inter se late Samir Kumar Yadav and the two plaintiffs is an admitted position of the plaintiff themselves. From the simple reading of the plaint, it is apparent that the two plaintiffs, Ramashankar Rai and Dinanath Rai, are surviving partners of an unregistered firm constituted on 29/11/2012. Deed whereof was registered under the Indian Registration Act, not under Section 59 of Partnership Act, and as such the status of instant partnership is of an unregistered firm. It is an admitted fact that the defendants herein are not the partners in the aforesaid firm, nor is there any contract in the deed of partnership to admit the legal representatives of a deed of partner as a partner to join the two surviving ones. Therefore, the plaintiff has no cause of action against the defendant to see any relief against them. The defendants, as described herein above, are neither parties to the said partnership nor they are partners in any reconstituted firm, if any. Therefore, provisions of Section 69(2) of the Partnership Act is relevant, which provides that no suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of the firm against a third party unless the firm is registered and the persons suing are or have been shown in the register of firms are partners in the firm. The partners, plaintiffs, actual grievance against the late Samir Kumar Yadav, the partner, as set forth in paragraph 7 of the plaint, appears to be non-furnishing of actual state of financial position of the partnership business. Clearly, the provisions of Section 69 of Partnership Act squarely covers the instant suit. The plaintiff's own pleading about the matter is halting. Paragraph 1 of the plaint contains an averment that the plaintiffs and late Samir Kumar Yadav executed deed of partnership and thereby they were partners. The plaintiff in paragraph 14 of the plaint claims 29 lakh as principal amount at the rate of 18% on the date of issuance of legal notice per annum by way of interest. These averments in the plaintiff's own pleadings indicate that it was not a simple money lending transaction for interest. It was some kind of business venture undertaken by the plaintiff with a view to do capital investment contributed by each partner to 25% of the total capital and the same share in profit as well as loss of the firm. In this state of things, it is not possible to accept the plaintiff's contention as raised in the plaint from the facts stated above. It is clear that the instant suit filed by the plaintiff is meant for settlement of account between the partners, but as the defendants are not privy to the said partnership, the suit is liable to be dismissed in limine. It is submitted that the suit in the present form and the relief claimed herein are not maintainable in view of the bar created under Section 69(2) of the Indian Partnership Act and also so and so. Evidence of the plaintiff and then
What is the finding then?
I may skip other two.
Yes. Evidence of the defendants.
Then issue wise finding in page 17,
Yes.
para 9.
Issue wise finding. Yes.
Issue number 1 and 2 are interconnected to each other, and then they are whether the suit is maintainable and whether any plaintiff has any cause of action. The specific assertion of the plaintiff that by playing fraud upon the plaintiff, 29 lakh was taken by Samir Kumar Yadav, defendant number so and so, in order to make part payment of rupees 10 lakh. Samir Kumar Yadav during his lifetime issued 3 checks in favor of plaintiff, and thus it is crystal clear that a civil liability is made out against defendant number 1 and 2, who are enjoying the movable and immovable properties left by Samir Kumar Yadav. And the instant suit has been filed within the period of limitation as well as the suit is maintainable and the plaintiffs have proved all the facts that they have averred in the plaint. Then issue number 3, whether the suit is barred by Section 69(2) of the Partnership Act. While discussing issue number 3, it is necessary to discuss material fact available on record. It is admitted case of both sides that one deed of partnership was executed on 29/11/2012 between Samir Kumar Yadav, since deceased husband of so and so, Dinanath Rai and Ramashankar Rai, the said deed of partnership was executed and registered before the district sub registrar so and so exhibit 1, which has
These
been
are the contents of the deed.
Yeah.
Then
Then I may skip to the
yes,
next.
you skip.
After the execution of the deed of partnership, page 18.
Yes.
Let me push.
Yes,
After
this
the
we have read it.
yes,
We have already seen all this. We have already argued. On different days, we have noted that on different days this happened.
yes.
What is the finding?
Their finding is page 21. It notes again quotes the section 69, and then the finding is that last para of page 22.
You just see altogether page 19 में ऊपर देखिए. Altogether 29 lakhs was paid, including rupees 13 lakhs of the dependent number 3 paid to the plaintiffs.
Yes.
है ना? इसके बाद?
These are the transactions. May I read further? Or?
No. What is the ultimate?
Yes,
finding?
ultimate finding is Your Lordship, after quoting section 69 and the two Supreme Court judgment, it says, page 22, last paragraph, in the suit at hand, that no contract had been entered into by the firm or the partners of the firm with the third party, nor it was entered into by the plaintiff firm or plaintiff in the course of his business dealing. Rather, the admitted fact is that the husband of defendant number 1, father of defendant number 2, Samir Kumar Yadav, by playing fraud upon the plaintiff and the defendant number 3, took 29 lakh, and then when it was detected, nothing was invested by Samir Kumar Yadav, nor he had any land in Khata number 96. Thereafter, the plaintiff started to make demand, and in order to repay the said amount, Samir Kumar Yadav had issued 3 checks of rupees so and so. On all these facts clearly suggestive of this fact that actually no partnership business had started, and the amount taken by Samir Kumar Yadav by playing fraud upon the plaintiff and the defendant number 3, and as such are engrafted under section 69(2) of the Act, and the principles so and so reflected in is not applicable in the case of hand, because the plaintiff had filed a suit for enforcement of statutory right or common law. So
basically, primarily on the ground that there is fraud and therefore the
fraud,
suit is
yes,
being
yes.
given.
Primarily,
But how do they come to a finding that there was, it is an admitted fact?
yes, no finding on
By
fraud.
playing, rather the admitted fact is that, and he is also saying, the court is also saying that even defendant number 3 was defrauded. Defendant number 3 does not come to say that defendant
Yes.
number 3 has been defrauded.
Yes, he does not, but he supports in his pleading. That is there. He supports in his pleading.
He supports
But
in his pleading that the plaintiffs have been defrauded.
Yes.
Or he says that he also has been defrauded.
That statement is there, but he does not file a suit. So this could not have been an admitted case of the parties where the plaintiffs have filed a suit, and taking note of the fraud, support of fraud by pro forma defendant, the court comes to this conclusion of fraud.
Then what about issue number 4?
Yes.
Defendant number 3 must have given WS. He supported the case
Yes,
of the
yes.
plaintiff.
What they
Did he
are
say
saying
that he
that
was
he-
also defrauded? Does he say that he was also defrauded? Who is for defendant number 3? Absent.
Yes. No one is.
Nobody had entered appearance also. Defendant number 3 से किसी का appearance नहीं है.
My learned friend, on the lighter side, not seriously. Because the defendant number 3 has been supporting him, therefore it was his duty
किसका
to.
किसका नाम है? थोड़ी absent है तो हम लोग को क्या मतलब? You have to see the records in past. 11 para number 11 पढ़िए तो. avoid that there is an arbitration clause, is that for better appreciation, now section 5, then
Likewise, Your Lordship is referring to para number 11.
para
Issue number
11.
4.
Yes, yes.
Whether the suit is barred by section 5 of so and so. The defendant number 1 and 2 in paragraph 2 of their written statement have averred that the partnership agreement contains a clause 7 which provides for resolution of dispute by arbitrator, and in view of section 5 of Arbitration and Conciliation Act, the present suit is not barred. For better appreciation, section 5 is quoted. Section 5 says, notwithstanding anything contained in any law, other law for the time in matters governed by this act, no judicial authority shall intervene except where so provided in this part. From the reading of this section, it is clear that the court has not been ousted from the jurisdiction to decide the dispute absolutely. Rather, this section itself provides that the judicial authority shall intervene if it is so. It is provided in Part 1 of Arbitration and Conciliation Act. Section 8 of the Arbitration and Conciliation Act stipulates that if there is an arbitration clause in the agreement and any matter which is the subject matter of arbitration agreement is brought before the judicial authority, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of his first statement on the substance of dispute, the court may refer the parties to the arbitration unless it finds prima facie no arbitration agreement exists. Thus, it is clear that the judicial authority can decide the matter in respect of dispute even if there is an arbitration.
Primarily on the ground that no petition under section 8 was filed.
Yes,
That is the only ground.
That is the
Otherwise, under section 5, a person claiming under the parties to the agreement, they also have a right to invoke section 5 and 8. Okay. Then this is the to whom the amount has been directed to be refunded.
to plaintiff. As a sequitur to the following analysis, the court is of the consider that plaintiffs have succeeded in proving itself. Hence, the suit of the plaintiff is decreed for recovery of 29 lakh only in so and so.
In favor of defendant number 1 and against the defendant number 1 and 2.
And so,
And the private party, that is the defendant number 3, is not aggrieved by this because the money had actually gone from defendant number 3.
yes. And no relief has been given. And how money advanced by defendant number 3 to the plaintiff and assuming to be paid to the could have been given to the plaintiff, not claimed by the original defendant. Therefore, at the outset itself, I had said, at best, whatever could have been the case, the plaintiff could have only said that 5 lakh I had paid, I was defrauded, I had paid, and therefore I am entitled to that.
चलिए क्या बोलना है?
Starting with the very point that is raised, why the defendant number 3 has not filed the suit? May I kindly see his written statement on para.
You see, this arbitration clause, I'm not with the judge. I'm
No,
making it very clear.
I'll verify.
If you still want to, if you want to give up, then
No.
I will record that you are giving up.
I'll not give up, but it is a question of law which I'll verify and then only I'll make my submission.
So on the last occasion, on that particular point, I had given one judgment of Karnataka High Court also. Again, that view is also supported by one Bombay High Court, where a specific reasoning is given why a written application under section 8 is necessary. A whole detail has been given as to why it is necessary, because it says that unless and until it is bring on writing as why this matter is fit for arbitration, the plaintiffs will not get to know about what are the grounds. So in the
And
written
otherwise, if there is an allegation of fraud, then the arbitrator may not have the jurisdiction to decide.
So nothing of that sort has come forward.
No, because there is an allegation of fraud over here.
Well, he says that unless the other party will not get to know what are the grounds for invoking section 8 minutes, unless it comes in writing, so that the other party gets an opportunity to reply to those particular points, and then it is decided on merit, because it excludes the jurisdiction of a court altogether. So it says that section 8 application, it's mandatory. Para 7 may be seen specifically. If I may read it.
Just para number
Para number 7 onwards.
of Bombay High Court judgment.
Bombay.
Yes.
So far as the submission and objection based on provision of section 8 and section 5 of the Arbitration Act is concerned, section 8 of the Arbitration Act
Para
is
7 में तो
guarding
so far as yes.
Therefore, para 8, power to refer parties to arbitration where there is arbitration agreement. Therefore, provision is quoted here. Therefore, para 8, it is clear from perusal of section 8 that a party who claims that suit which is pending before the court is subject of an arbitration agreement has to make an application to the court not later than when submitting his first statement on the substance of dispute for referring the parties to arbitration. Subsection 2 of section 8 further lays down that an application under subsection 1 for referring the parties to arbitration shall not be entertained unless it is accompanied by the original arbitration agreement or duly certified copy thereof. In my opinion, the proviso of subsection 2 of section 8 indicate that the application that is contemplated by subsection 1 is a written application and not merely an oral application. The Supreme Court's by judgment in the case of P. Anand Gajpati Raju versus PVG Raju has laid down the requirements that have to be satisfied before the court. Para 5 of the judgment of the Supreme Court in P. Anand case reads as under. The conditions which are required to be satisfied under subsection 1 and 2 of section 8 before the court can exercise its power are: there is an arbitration agreement, a party to agreement brings an action in the court against the other party, subject matter of the action is same as subject matter of arbitration agreement, the other party moves the court for referring the parties to arbitration before it submits its first statement on the substance of dispute. It is clear from these observations that one of the aspects to be considered by the court while considering the application for referring the parties to arbitration is that the subject matter of action is the same as the subject matter of arbitration agreement. Now, this requirement will involve reference to the contents of the claim as also to the arbitration agreement and the manner in which applicants wants the court to read the averments made in plaint, as also the recital in the arbitration agreement. It is obvious that the plaintiff who has brought the action would also have the right of audience on such an application. In order to afford the plaintiff a complete opportunity of being heard on an application under section 8 of the Arbitration Act, in my opinion, it would have to be held that the party which seeks to refer the dispute to arbitrator has to make a written application for that purpose, so that the plaintiff who has instituted the suit knows exactly the ground on which the reference is sought. This is the reasoning maps. Earlier maps, I had given the Karnataka High Court judgment where in para 11 the same thing almost has been held at. There has to be a written application.
Karnataka High Court was waiting that judgment.
Karnataka High Court judgment was once.
Karnataka High Court, I am not looking at.
So I had given on last week.
हाँ must have. देखिए तो कहीं है. हाँ ये था इसमें. Wait. इसका पैरा.
So it is 12-11 minutes.
This judgment has been followed.
The judgment of Bombay High Court has been followed subsequently.
In Karnataka.
No matters. In the subsequent.
In which case?
Essentially, the dispute with respect to Section 8 application was when it ought to be given. So, the recent interpretation are with respect to it should have been given before filing written statement.
So
But in this
basically,
case,
it is in the nature of rejection of plaint.
ultimately,
One
This is what-
one clarification is required. Now this amendment, new section, this amendment came into force on 23/10/2015, and the suit had already been filed and the WS had
Which
also-
amendment came into force?
इस केस में WS had already been filed. Therefore,
कौन सा amendment की बात?
ये जो amendment in arbitration and conciliation,
Which section was it?
section 8 was amended.
Section 8 was amended.
Yes, yes.
Inserting what?
In relation to, because there were
It
certain.
was always there.
Section 8 was there, but it was amended so far as there were certain judgments of Honorable Supreme Court, and therefore that led to that amendment. So we have, I'm just
That
pointing out
specific application is to be filed.
no, I'm just pointing out that we have to see it according to the law that was existing on that.
That's right.
That is the reason.
On the date of suit.
Yes, that is the reason. I'll just verify this. I'll verify your lordship, therefore I say.
और बताइए आप क्या?
few of the points with respect to section 69(2), my lords. I will read it from the judgment itself, my lords. But one of the essential point that has come up, my lords, as in the trial court judgment, is that whether it excludes only the right under the Partnership Act or arising out of a contract, or it excludes every right. The finding with respect to the judgments that I have come across says that the common law rights are not barred by way of 69. There is a
Common law right arising out of fraud in the present case.
in the otherwise also, my lords, there are judgments in a Patna High Court judgment of a division bench. It has been held that right to recover money is a common law right. If any person gives money to something, he wants to recover it, that arises out, that is a common law remedy. And there is another judgment of the Honorable Supreme Court of 1993. It says that unless there is a specific statute which specifically bars a particular common law right, that cannot be curtailed. So 69(2) only bars the right that arises from the Partnership Act or from a contract. It doesn't bar common law rights. And my right to recover this particular money, that was given specifically to Samir Kumar Yadav. The said fact is admitted because the firm part under the agreement, their account of the firm was to be opened. It was mandatory. Term is has to be opened. It was never opened. Samir Kumar Yadav took the money, and thereafter, in return, he issued 3 checks. That all 3 checks were issued by Samir Kumar Yadav himself. So he acknowledges himself that those liability were not of firms. Otherwise, the checks in return he would have issued would have been of a firm. The firm was even not named by us. In the agreement, there is no name of firm. So the partnership business had not at all started. My right is a common law right to recover money from Samir Kumar Yadav.
Partnership business might not have been started, but partnership had started.
Partnership had started.
But business might not have started.
Might start.
But
Samir,
different, all the 3 persons had pooled in money in the partnership.
well,
business.
those money could have been pooled in only after the account of the firm would have been opened as per the agreement. Kindly see Exhibit 1. The agreement itself. clause 6 says that, my lord,
The-
that the bank account
reason
shall
which
be
I will-
opened.
Yes, but bank account was not opened.
No, my lord. Sameer Kumar Yadav took the money and instead of investing in firm, he defrauded us. So this is the fraud committed by Sameer Kumar Yadav in his personal capacity, my lord. And it was upon the plaintiff to file, my lord, even filing a criminal case would not have helped us recover money. In this case, he agreed to return the money and he made part payment. So in that case, no criminal remedy
Part
was
payment
pursued.
was made to whom?
To us, my lord, directly. To the plaintiffs.
To the plaintiffs.
He issued
Check
checks
he-
of 10
in whose
lakhs
name?
rupees.
In whose name?
Now these are exhibit 3, my lord, kindly see. In our name itself.
दोनों के नाम से jointly.
My lord, kindly see the exhibit 3, it is only in the name of plaintiff number 1. Exhibit 3, my lord, kindly see. In the name of Rama Shankar Rai, the plaintiff number 1. All 3 checks he has issued. All are signed by Sameer Kumar
You
Yadav
are
in his personal
representing
capacity.
both. You are representing both the plaintiffs.
My lord. So, my lord, when he has taken money and he himself acknowledges return of that money to me in his personal capacity, then so his liability becomes his. But with respect to the
How do you link this payment to the money taken?
my lord,
How do you link this payment to the money which was advanced?
must be all these checks were after.
Merely because a check is issued after, does that mean that it is on account of repayment of some amount?
Because there are abutment that has not been controverted, matters. They have not been examined. The defendants in this case have not bothered to examine themselves, neither minor. They have done anything further. So whatever claims I have made have become admissions.
Defendants had no knowledge. So their examination, non-examination would not have made any difference. They are not saying anything from their personal knowledge.
But even if we assume the check issued pursuant to our claim, it prima facie establishes that he had issued those checks for discharge of some liability.
Not necessarily. This presumption is there only under Negotiable Instruments Act.
My lords. But
But is this presumption available even under law?
because my lords, the
Under common law, is it available? That merely because a check is issued, can it be said that it has been issued in discharge of a debt? This presumption is there in Negotiable Instruments Act. But is it there in civil law also?
Once in civil law, the principles of the check, whether this check is to be admitted or not, it has to be looked only from the fact that under the negotiable instrument law, it provides that it raises a presumption.
No. This presumption that it has been issued under a debt is for the purposes of section 138 of Negotiable Instruments Act. That is the criminal liability.
But for any purpose, it just shows that he owed me something.
दिखाइए नेगोशिएबल इंस्ट्रूमेंट्स एक्ट में कि चेक इशू करने से ही हो जाएगा अंडर सिविल लायबिलिटी दैट इट हैज बीन इशूड अंडर अगेंस्ट अ डेट. दो चीज है देखिए इसको दोनों चीज हम लोग को देखना. There are two people who say that defendant number 3 had advanced money at their instance and he issued check directly in the name of the deceased person. Correct? And then you say that the deceased issued check only in the name of plaintiff number 1 and amounting to rupees 10 lakhs, and this payment was in discharge of his liability.
Because the reason why this whole thing has happened, Malos, may kindly see the written statement of defendant number 3, point B, Malos. Why he has not come forward, why I have come forward, Malos. Malos, may kindly see that. I will read it, Malos. That it is further submitted that the plaintiff as well as Sameer Kumar Yadav had assured the defendant number 3 that his money would be saved and the plaintiff would pay the amount from his share. As for defendant number 3, the liability to repay his amount is with me, not with Sameer Kumar Yadav. So, he had no right to file the case. So, I filed the case because Sameer Kumar Yadav, by way of exhibit 2, 21 and 22, by all the 3 exhibits, he admits that he received entire 29 lakh rupees from me, not from
But defendant number 3. So defendant number 3 was to recover money from you.
From me.
He has not filed it.
He has not filed it. So the matter, I am arguing this point just to show that there is no requirement with respect to the privity I am addressing. Although he gave a check to the plaintiff to Sameer Kumar Yadav, he has not filed any case because liability rests with me. For entire 29 lakh rupees, I am entitled to recover, and with respect to those amount that was forwarded by defendant number 3, I am entitled, I have a liability to repay him.
कल एक दिन और सुनेंगे.
So I just have quick balance. May just see the entire 69(2) has been addressed with reference to two particular Supreme Court judgments. Those judgments I would just like to forward. It has been relied upon by the trial court. May also consider it the relevant part.
That is with respect to fraud.
It just says that when there is it is a common law right. Not all the rights are barred under 69(2). Only the contractual right and the rights arising out of partnership act are barred. And in this case,
So this recovery of this money
is a common law remedy.
is not arising out of the contract.
No, it is not arising out of that partnership agreement because neither the firm is a party, neither the money went to the firm's account, nor the firm returned me any check. All the money was taken by Samir Kumar Yadav that he will invest in that particular project. He didn't invest it, he committed a fraud, and thereafter, he himself agreed and returned 10 lakh rupees and said that he would return me in part payment, make part payments further. So I didn't file any case against him because anyhow, my lords, it would have been a compoundable offence. So I would have always compounded it. So my lords, in case he would have refunded all the money, I would have not filed any case. My purpose was to get refund of my money. So I chose this particular remedy instead of filing a criminal case or any other case.
And there was no occasion to present the check.
But the reasoning itself is a sign that he says that he is very much ill. He is not well. So I should not encash those checks.
Appearance record. Post for further hearing tomorrow. आज हम इसको पढ़ लेंगे पूरा इत्मीनान से. एक आध क्वेरी हमारा रहेगा. 1 घंटा में खत्म हो जाना चाहिए मैक्सिमम. ये आर्बिट्रेशन वाला आप देख लेना.
हम देख सकते
Common law right for the matters of judgment.
देख.
Para 13. This was different. This judgment with respect to this one also. These issues. But the concept of fraud has been dealt with in Madras High Court judgment. Para 13 onwards.
आप एक काम करिए, थोड़ा 2 मिनट लगाइए और आपके जो जो जजमेंट्स है ना सब एक जगह कर, क्योंकि कंफ्यूजन हो जाएगा दोनों का. है ना? मेरे ख्याल से ऐसा ये आपने दिया है 95(2).
हम लोग अलग अलग कर देंगे आप.
इसको अलग अलग करा. ये रिस्पोंडेंट ने दिया है, ये रिस्पोंडेंट का है, ये भी रिस्पोंडेंट का है. ये सारा चीज़ रिस्पोंडेंट का. जो जो पैराग्राफ आप कर रहे हैं आप पहले उसको मार्क कर दीजिए. पैरा नंबर ऊपर ही लिख दीजिए. अपीना ने 2 ही जजमेंट दिया.
ठीक है, हाँ 2 ही.
ठीक है. इसमें कौन सा 22 वॉल्यूम 2 का कौन सा पैरा है? पैरा 9, 9 to 12.
हाँ.
आपका कहना ये है कि फ्रॉड और नो फ्रॉड पार्टनरशिप से अराइज नहीं करता, इसीलिए पार्टनरशिप का वो जो बार है वो इसमें नहीं है.
This is also
This
one
is
of the
what-
alternate arguments.
Your
Otherwise, once I say that there is a fraud.
I said that's right. You say that there is a fraud.
Fraud. Even otherwise, my lord, the case is maintainable.
अब तो आप नोट बनाएंगे ना भाई, परसों रख दें, लेकिन नोट हमको चाहिए, ऐसा नहीं.
My lord, may keep it day after tomorrow.
परसों रखते हैं।
detail.
हाँ हाँ
आप लोग अब जितना बहस कर लिए हैं भाई उसके बेसिस पे एक तो नोट बना के
नहीं नहीं कर देंगे बताएं हुआ लेकिन वो और
अब समझ आ गया ना
हाँ,
बस
हाँ,
अब तो सारा कंक्लूड
ठीक,
क्लियर हो
ठीक,
गया
ठीक,
अब नोट बना
ठीक।
पोस्ट दिस केस डे आफ्टर टुडे at 2:15 as usual
ठीक
for further hearing.
May I mention one case?
क्या हुआ
Item number 11 for daily use orders case here.
क्या है ऑर्डर्स क्या हो गया
The CCL has acquired the landed property of mining also. Today itself, no award has been received by me. Land was acquired in the year 1990.
कितना ऑर्डर्स केस है आज सब लोग हैं चलिए लाइए ऑर्डर्स देखते हैं ऑर्डर्स में क्या क्या है उसको पैक करना 5 मिनट लगेगा कर लेंगे रुक जाइए ऑर्डर्स के जो रहेंगे उनका कर देंगे जो नहीं रहेंगे उनका एडजस्ट कर देंगे
I am the respondent here.
रुक जाइए एक सेकंड
Orders at a week, 2nd April 360 of 2016.
ये किनका है बताइए
Item 8.
हाँ आइटम 8
Notices in order to be issued.
notices were issued
Yes, sir.
क्या हुआ नोटिस पर बताइए आपने नहीं देखा है ऑफिस नोट नहीं देखा है नहीं देखा है तो अभी हमको 5 बजे क्यों देखना है आपका ऑफिस नोट उनको दे दीजिए अपना फाइल का ऑफिस नोट अब अगला डेट में देखिए
Item 9, 2nd April 375 of 2016.
हाँ बताइए
Serial 8, we have received the order number, we will be filing it.
सीरियल 8 आपका है सीरियल 8 सीरियल 8 किसका है ये कौन सा सीरियल नंबर
Serial 9.
आपका अभी सीरियल 8 है किसकी तरफ से आपको वकालतनामा मिला है
Respondent.
कौन रेस्पोंडेंट कुछ नहीं पता आपको जिसकी तरफ से मिला है वकालतनामा फाइल कर दीजिए फ्रेश ऑफिस नोट से अगली डेट में आ जाएगा और ये किसका है
Item 9.
ऐसे नंबर 375 of 2016 as per office note no petition for substitution of appealer number 8 has been filed post on 3rd April.
Item 10, 1st April 88 of 2017.
Substitution.
Two I are there. One is substitution, one is for continuation of the delay matter. And already similarly situated cases the delay has been controlled.
Respondent नहीं है ना आपका कितना मैटर है कितने मैटर्स हैं
आज एक ही
इसको कल कर दीजिए रेस्पोंडेंट के बिना सुनवाई नहीं कर सकते 5-4:30 बजे के बाद पोस्ट टुमारो कल वो लोग नहीं भी रहेंगे तो कर दीजिए
Item 11, 1st April 210 of 2019.
हाँ बताइए
There's an IA 10378 of 2019, which
और
has been filed under Section 5 of limitation. There is a delay of 243 days in preparing the appeal.
आप किनकी तरफ से हैं
Respondent side से हैं.
कौन से रेस्पोंडेंट
3 to 1 to 5.
कोई ऑब्जेक्शन है आपको
नहीं.
आइए नंबर कितना बताएं
10378 of 2019.
2009
19.
19. 19.
what is the reason for delay
It's mentioned it in para number 4, 5 and 6. After the order was passed, I applied for the certified copy which was supplied to me on
FA number 210 of 2019 with IA number 10378 of 2019. Counsel for the parties are present. You are representing all the respondents?
All the respondents.
IA has been filed for condonation of delay of 243 days. The learned counsel for the appellant has referred to paragraph 4, 5 and 6. Counsel for the respondents has submitted that he has no serious objection so far as condonation of delay is concerned. Considering the submissions and being satisfied with the cause shown in the interlocutory application, IA is seeking condonation of delay. Delay in filing this appeal is hereby condoned. और कोई defect है?
No.
Admit. No notice need be issued as the respondents have already entered the pleadings. Post this, let the records be called for from the concerned court. Post on 15th April. Let this order be communicated. आप सारे respondents की तरफ से हैं ना? You are sure? Counsel for the respondents इनका नाम दे दीजिए. He submits
Rajesh
that
Kumar.
he is Rajesh Kumar, that he is representing all the respondents in this case.
Rajesh Kumar Mishra.
हाँ, दे दीजिए. नाम अपना लिख दीजिए. हो गया?
Item 12, second into 269 of 2019.
Yes.
On the last day, we had a substitution petition of respondent number 1A.
So,
Your Lordship, we could not find because we don't have the details of the deceased, Your Lordship. And all the respondents are related to each other. If the respondent would be directed to give us the
I'm aware
details.
of all the respondents, but not the substituted ones.
उनकी तरफ से आप बताइए. Who informed
We have
this?
no instructions regarding the address of the respondent number 1A, Your Lordship, the address.
1A has expired.
Yes, Your
Yes,
Lordship.
Your Lordship.
So he has to be substituted.
Sheila Devi.
She has to be substituted.
Report was received, Your Lordship, before the last date.
Sheila Devi. 1A. Late of, son of late. क्या नाम लिखे? मनदास. आप 1B की तरफ से अपीयर कर रहे हैं?
नहीं, Your Lordship. Respondent number 1, 2, 3, 4 की तरफ से अपीयर कर रहे थे, Your Lordship. But लेकिन substituted जो respondent number 1 के जो भी legal heirs उनको represent नहीं कर
तो उनको नोटिस नहीं किया है?
गए
इशू हुआ है.
बाकी लोग की तरफ से कोई अपीयर नहीं हुआ
नहीं
है?
पहुंचा. अभी रिपोर्ट में आया है कि everyone has received and 1A का substitution हमने फाइल किया. That is why it has come for orders.
Respond number 4, it has abated.
Yes.
Okay. Essay number 269 of 2019. Respondent number 1A. Was reported dead as back as on 29/2023. Notice upon respondent number 1B, 1C, 1D, and 2 is received by either themselves or by their family members. Partition suit नहीं है ना? Accordingly, the notice upon respondent number 1B, 1C, 1D, and 2 is accepted as valid. The appeal has already abated against respondent number 4 by the order dated 22/6/2023. Respondent number 3 is appearing. आप किस 2 की तरफ से भी हैं क्या?
Yes, Your Lordship.
Counsel for respondent number 2 and 3 is appearing before this court. let this matter be listed on 3rd of April 25, awaiting appearance of respond number 1B, 1C, 1D, who may be in a position to disclose the details of legal years and successes of 1A. As the counsel for the appellant has submitted that she does not have any information about the legal years and successes of respond number 1A. क्या होगा नहीं होगा आखिर तो
Execution case with pending and also we will have to verify the execution proceeding, what is happening with the deceased.
she submits that execution case is also pending
Which is filed by
and she may take instructions as to whether the respondent number 1A has been substituted in the execution proceedings. Appropriate affidavit be filed by the appellant. आप अपना प्रॉपर एफिडेविट फाइल करिए कि आपको पता नहीं है एड्रेस क्या है, ऐसे बोलने से आपका स्टेटमेंट नहीं चलेगा ना. You file an affidavit. Counsel for the appellant is directed to seek instructions and file appropriate affidavit. डेट तो दिए, कब का डेट दिए? अप्रैल का कोई डेट नहीं, 3rd April. बस अभी बाकी है. कौन है और कौन है? आप
Item
हैं?
13.
हाँ बताइए
Item 13.
क्या हो?
on last occasion notices were issued.
ऑफिस नोट क्या है?
ऑफिस नोट में आया है कि वो सर्वर नहीं ट्रैक कंसाइनमेंट पर ट्रैकिंग रिपोर्ट पर हम ऑनलाइन देख रहे थे वो डिलीवर्ड दिखा.
ऑफिस को दिखा लेंगे, ऑफिस को जाके दिखा लेंगे, ठीक है ना. FA number 43 of 2022 posed this case on 3rd April. ऑफिस को दिखा लेंगे, बोलो वहाँ से प्रिंट निकाल.
Item 14. For 2nd April 2012 of 2023.
Should not take it.